Please be seated. We'll hear argument in 21-127, In Re GS.
May it please the court, Mr. Radford will present argument for the relator. The relator has reserved 5 minutes for rebuttal.
May it please the court, counsel. Today before us, we have another compensation case under the Tim Cole Act. And I believe there are two issues that we're going to be discussing today. With the leave of the court, I would like to address the actual innocence claim first and then discuss the limitations claim. My client was incarcerated under a statute that he pled guilty to, and after serving approximately 3.5 years in prison, he filed a writ of habeas corpus based upon ineffective assistance of counsel. The Court of Criminal Appeals granted that writ of habeas corpus and remanded the case back to the district court for a new trial. After further investigation and some statements that were given to the district attorney dismissed that case. And in the notes on the dismissal, noted pending further investigation. After that, the victim gave a statement recanting, and the prosecutor agreed to an expunction. Following that, the realtor filed an application for compensation under the Tim Cole Act. That was denied by the comptroller. That was in 2015. There were, I think, 3 or 4 subsequent applications that were filed, and all of those were denied, and that leads us here today. I would submit that this case is almost identical to In Re Billy Frederick Allen, that this court decided almost a decade ago, that applied Schlup-type relief to actual innocence claims under the Tim Cole Act. In the Allen case, and I have included a copy of the Allen Court of Criminal Appeals opinion, the Court of Criminal Appeals specifically granted Allen relief under ineffective assistance of counsel. Now, it's noted throughout the opinion in the Court of Criminal Appeals that there was exculpatory evidence that Allen's attorney failed to develop and investigate. But the bottom line, under the conclusion in their opinion, it says, we grant relief under ineffective assistance of counsel. And that case was remanded back to the district court for retrial.
Does it matter that the underlying ineffective assistance has to do with, in this case, the availability, failure to properly advise about the availability of parole in connection with the guilty plea, as opposed to a claim that's more tethered to exculpatory evidence or evidence of actual innocence?
I want to develop that further because I think when you take into account all of the evidence that the victim recanted, that the prosecutor dismissed the case pending further investigation. Now, what does pending further investigation mean? That means I can't make my case right now. And that goes back to our core presumption of criminal jurisprudence. We are presumed innocent until proven guilty. So when a prosecutor dismisses his case saying, I need more investigation, what does that say? I cannot make my case at this time. And then he later agrees to an expunction, which I would submit ratifies the presumption of innocence. So, but going back to Allen, Allen was not retried, but could have been retried. And this court notes that still, while it is unlikely, it is conceivable that the state could compensate someone who is later found guilty of the crime, as in Allen, because they could have retried Allen. Just as someone could be imprisoned for a crime he did not commit, the state could erroneously compensate someone who committed the crime for which he was incarcerated. The imperfection of humanity means that the state may make mistakes, but that possibility does not vitiate the government's interest in avoiding injustice. In the Allen case, the prosecutor dismissed that case based upon destruction of physical evidence, the death of a fact witness, the failing memory of another fact witness, and the passage of time over the trial. The prosecutor did not note in that case that Mr. Allen was actually innocent. However, this court granted relief under the Tim Cole Act based upon the Schlup constitutional gateway that states a constitutional violation.
Did your client have to pass through the Schlup gateway?
I think so, yes.
Why is that?
Because that is what has happened. That's the precedent this court set in Allen. And I think he passed through the Schlup gateway. When he was remanded for a new trial, we start over.
No, I mean, in the Court of Criminal Appeals, what about the Court of Criminal Appeals proceeding or its decision in this case indicates that your client passed through the Schlup gateway in that proceeding?
They granted him a new trial just as they did in the Allen case. It was the same grounds, ineffective assistance of counsel under Strickland.
But was this his first post-conviction writ application or
Yes,
a
it wa-
subsequent one?
Yes, it was.
So he didn't have to pass through the Schlup gateway because it wasn't a successive petition?
I think he has to pass through the Schlup gateway to receive compensation here, because that's what Allen
Right,
says.
but I think what Justice Blacklock was asking is what in the Court of Criminal Appeals decision on his application for, on his post-conviction application shows that he did pass through the Schlup gateway in that case.
Oh, maybe I misunderstood. I don't think he was required to pass through Schlup in that case. He was remanded a new trial because of ineffective assistance of counsel, just as in Allen.
But in Allen, he did have to pass through the Schlup gateway because it was a successive petition.
Yes, sir. Yes, sir. I think it was a fifth or sixth writ that was
Right.
filed in Allen. So yes, he did have to gain that extra hurdle in Schlup.
And isn't that what matters for Tim Cole Act compensation purposes?
I would suggest that it doesn't, because Allen says that this court can look at Schlup and see that a constitutional violation a constitutional right has been violated. And in that case, we have an indictment that was, again, kicked back and then subsequently dismissed. Now, there is a third requirement under the Tim Cole Act that allows for compensation where the applicant gets habeas relief and then the indictment is subsequently dismissed, and then the prosecutor in the motion to dismiss states that the defendant is actually innocent, or that
Either in the motion or in an affidavit?
yes, in an affidavit, excuse me, that's what I was thinking. He had to have either motion or affidavit. I would submit you're not going to get a prosecutor that is going to write on a motion to dismiss that the defendant is innocent and should never have been prosecuted. I think that opens them up to a wide variety of criticism. However, in this case, we had the prosecutor say, pending further investigation, which then kicks back in the presumption of innocence. So when the prosecutor dismisses the case, saying, I need to investigate more, and upon further investigation agrees to an expunction, I would submit that that is actual innocence. I have just a bit of time left. I'd like to talk about
You know, that makes sense, that makes sense. That when you've got the dismissal and the retraction and the expunction that appear in this record, that a court could, at a minimum, infer actual innocence, even not granting value to the presumption, right?
Yes, sir.
But aren't we bound here not by what makes sense, but rather by what the statute requires? And the statute doesn't say, hey, if the dismissal and expunction and witness retraction all combine to make it clear that he was innocent, then you qualify. Instead, the statute says you got to either have the CCA say this or you got to have the prosecutor say that, one or the other. So how do we get around the statute here?
The Allen Court.
Well, but in Allen, so the deal with Allen was the CCA could not address the ground for the habeas petition was ineffective assistance, but because he had already filed a series of habeas petitions, the Court of Criminal Appeals had no power to address that ground unless it first found actual innocence. And so what we said in Allen was, well, look, the CCA could not have done what it did without having found actual innocence. Whereas here, the CCA could address ineffective assistance without having first found actual innocence, because there was not a series of habeas petitions prior to this one, right?
Yes, sir.
So doesn't that distinguish Allen? There is no necessarily implied finding of actual innocence in this CCA opinion.
There was no intrinsic finding of actual innocence in the Allen opinion.
But there had to be, and that was the whole analysis of Allen, is there's no way the CCA could have even reached ineffective assistance, the constitutional claim, without first having found the fundamental error of actual innocence.
I would submit that if the Allen Court of Criminal Appeals had found actual innocence, they would have reversed and rendered. Instead, they reversed and remanded for a new trial. And so the prosecutor in Allen had the option of retrying Allen. Therefore, if you have a finding of actual innocence by the Court of Criminal Appeals, then you're going to get a reverse and render. And then the respondent or the defendant will be discharged. That wasn't done in Allen because he was reversed and remanded for a new trial. So, with leave, I just have a few minutes. I'd like to talk about the limitations issue. The respondent has alleged that that the petition of writ of mandamus was filed outside of the 3-year period. The statute specifically states that an applicant has a 3-year period to file an application. It does not state the word limitations. The statute of limitations is a different animal, because what that means is I have 3 years that I can file an application. And the realtor in this case did that. He filed 2 applications within those 3-year periods. So he's within the statute. He subsequently filed, it was either 2 or 3 more, so he continued to file applications even though they were denied.
Which application does your mandamus petition relate to?
It relates to the 2015 and the 2016 applications. Those were the 2 that were filed within the 3-year application period. But it's not, I would submit to the court that this is not a limitations period. I can file my application for compensation 2 years and 364 days and be within the statute. But what if the comptroller denies it? If you believe the comptroller's argument that there's a 3-year limitations period, that means I don't have a recourse. I cannot file a writ of mandamus. I cannot file suit to remedy my grievance. So I submit that this court look at Article 16.
Why would that be? If you file one within the 3-year period and it's denied, you can mandamus and say you had a duty to grant that. I'm not following you.
Their argument is that after 3 years, you can't file it. That's what their brief said, is that the 3-year period runs, you can't file a mandamus after 3 years. And
But I thought the argument was you can't file an application after 3 years. And they can't have a ministerial duty to grant an untimely application. And so you can't win a mandamus action related to an untimely application.
if I file my application within 3 years, let's say I file it at 2 years and 364 days, and 30 days later, because they have 30 days to respond, they deny it, I should be able to file my mandamus. I have filed my application within the time period under the statute, and I have been denied. I file my application to cure, and it's denied. I then should be able to file a mandamus action. And since there's no actual limitations in the Tim Cole Act, I would submit that we fall back on 16.051 of the Texas Civil Practice and Remedies Code. I'm running over time.
Any other questions? Thank you, Mr. Radford.
Thank you, Your Honor.
We'll hear from the state.
May it please the court, Mr. Leinberger will present argument for the real party in interest.
May it please the court. GS is not entitled to mandamus relief for 3 reasons. First, I believe I've now heard my friend on the other side concede that that GS's 2017, 2018, and 2019 applications for compensation are barred by limitations.
Thought he said that 2016 and 2017 were timely.
I didn't hear that, but I think he meant to say his 2015 and 2016 applications for compensation were timely. The second reason why he should be denied mandamus relief is because his mandamus petition relating to his 2015 and 2016 applications for compensation is barred by laches. And the third reason his mandamus petition should be denied is even if laches doesn't bar his mandamus petition, he is still not entitled to mandamus relief because the comptroller correctly determined that GS is not an eligible claimant under Section 103.001 A2B of the Tim Cole Act. So beginning with laches. His 2015 and 2016 applications for compensation are the subject of his mandamus petition. But he delayed in filing his mandamus petition regarding those applications. In the case of the 2015 application, he waited 5 years, 1 month, and several days to file that mandamus petition after his application to cure was denied in 2015. And regarding his 2016 application, he delayed 4 years, 1 month, and several days after his application for compensation was denied to seek mandamus relief in 2021. The comptroller submits that those delays are manifestly unreasonable, and further that they're inexcusable because GS knew in 2015 that he was entitled to seek mandamus relief if his claim was denied. And we know that because if the court will look at the mandamus record at page 15, he stated that he knew that in a cover letter accompanying his application for compensation in 2015. And
The charges against him were dismissed on June 16th, 2015. I see. And then there was, I see. Sorry, go ahead.
Yes, Your Honor. And the comptroller would further submit that he is entitled to have GS's mandamus petition barred by laches because the comptroller's prejudiced.
Isn't there sort of a difference, though, between filing your application is denied and then just nothing happens, you're just sleeping on your rights for something, and suddenly there's a mandamus, whereas here there were other efforts made to invoke the administrative process, which is just seems fundamentally different than what we think of with laches, where there's just a delay without any explanation at all.
I think laches applies, Your Honor, because as I mentioned, his merely filing seriatim applications isn't reasonable and doesn't excuse him when he knew that he had a right to seek mandamus relief in 2015 when his application was denied. And so I don't think he kept it alive by just delaying to seek mandamus review in this court. He should have sought it, and back in, I believe his petition or his application was denied in December, so reasonably, he should have brought a mandamus petition and got it decided sometime in 2016, but he didn't. And because he didn't do that, and he kept filing these seriatim, repetitious applications, the comptroller had to waste resources to continue to process these claims, and it also denied the comptroller the advantage of finality here. The Act contemplates that these claims should be wrapped up around 3 years. This one has been going on for way too many years.
What do you think the answer is to your friend on the other side's pointing out you file it 2 years and 364 days later? When do you think he had a duty to have filed a mandamus, if someone were to do that?
He had a duty to file the mandamus after his application to cure was denied in 2015. And with regard to his 2016 application for compensation, he had a duty to file a mandamus petition after his application for compensation was denied.
How long after those?
A reasonable time. The common law doctrine of laches should apply here, and that the length of time should be a reasonable length of time until he has to file his mandamus petition. The section 103.051E creates this entitlement to judicial review after your claim is denied. It doesn't set a time limit. So the comptroller would say that but legislature not setting a time limit for the petition for writ of mandamus, that incorporates that laches jurisprudence in there, and I believe laches jurisprudence would say you need to have, it needs to be filed in a reasonable time, and that's why I say under this record, it is manifestly unreasonable to wait that long to seek mandamus review.
Why wouldn't we default to the default 4-year statute of limitations?
Several reasons, Your Honor. First of all, my friend on the other side cites no cases that say that Section 16.051 of the Civil Practice and Remedies Code applies to the Tim Cole Act, first of all.
Why wouldn't it?
I would say because when we're talking about 16.051, it only applies when there isn't an express limitations period. Here we have one.
Well,
now,
not for filing the mandamus petition.
No.
You have one for filing the
No.
application.
That's right. That's right. So he's trying to use a residual statute of limitations for a judicial review provision. And 1605 residual limitations period shouldn't apply to this judicial review provision under Section 103.051E because that's judicial review, and since there's no time limit on filing the mandamus application, that's why I say the common law of laches would apply there to bar it. So
if it's judicial review of an agency determination, does the Administrative Procedure Act? Are you saying that this falls under the Administrative Procedure Act somehow?
No, Your Honor. I'm
Okay.
saying that if the comptroller denies a person's claim, that
Right.
person the legislature has provided a way for that person to get judicial review of that decision. That's all
By
I'm saying.
mandamus here. But if, I don't know, if it's not judicial review in the sense of Administrative Procedure Act, then I'm not sure I follow why the default statute of limitations would not apply.
Your Honor, I think it doesn't apply for the reason I stated. It only applies when there is not an express limitations period. Here there is an express limitations period. That's 103.003 of the Tim Cole Act. And my friend on the other side says, oh, well, this doesn't say anything about limitations. That's not true. The heading for section 103.003 says limitations. So we have an express limitations period here. It applies, therefore 16.051 doesn't apply. And in any event, we're talking about seeking mandamus review. And as this court is well aware, the traps don't have a time limit for filing a mandamus petition. The doctrine of latches applies. The legislature, by not providing a period for filing the mandamus petition, therefore incorporated all the case law regarding latches. And I would now like to turn to eligibility and just say that even if the court doesn't agree with the comptroller on latches, GS is not entitled to mandamus relief here because he is not eligible for compensation under the Tim Cole Act, as the comptroller correctly determined. The provision under which GS is seeking compensation is section 103.001A2B. That provision states a person must have been granted relief in accordance with a writ of habeas corpus that is based on a court finding or determination that the person is actually innocent of the crime for which the person was sentenced. GS does not meet those requirements in this case. He did not get a habeas order that contains a court finding that he is actually innocent. The only relief he got was ineffective assistance of trial counsel based on a violation of the Sixth Amendment. Nothing in the Court of Criminal Appeals opinion, either expressly, impliedly, or even looking behind it, would even suggest that the court found or determined GS to be actually innocent. And I submit there's two reasons why the court didn't make that finding. First of all, the declarations on which GS is basing his allegation that he's actually innocent, they didn't even exist when the Court of Criminal Appeals rendered its decision in 2014.
If
The second-
the witness had recanted before the habeas proceeding, and that was part of the Court of Criminal Appeals decision in granting relief, would that have been sufficient in your mind to meet the statute?
Yes, if I could add another fact to Your Honor's hypothetical. If that was before the court and the court made a finding of actual innocence, and then GS had presented an application for compensation that included an order that said that, the comptroller would have granted his claim, no questions asked. The second reason that this habeas order does not qualify him for compensation is exactly as Justice Boyd was questions we're getting into. In this case, the court did not need to make an actual innocence finding based on schlup, which is what my friend on the other side says he got. It did not need to make a schlup finding because this was this was not a subsequent habeas application that was procedurally barred as an abuse of the writ. And only in that situation does someone have to pass through the schlup gateway by proving it's more likely than not that if this newly discovered evidence had been considered by the jury, no rational juror would have convicted them. That didn't happen here. So for the simple reasons that the declarations weren't even in existence, and two, he didn't have to pass through the schlup gateway, there's nothing in this habeas order that the comptroller can look at to determine that this person is actually innocent. And I will say the other critical provision here regarding determining eligibility is section 103.051B-1. That provision tells the comptroller that if there is not a clear indication on the face of the documents that the person is eligible for compensation under section 103.001A2, then the comptroller shall deny the claim. And furthermore, in that provision, that provision also tells the comptroller what documents the comptroller is allowed to look at. And those documents are a pardon, a court order, a motion to dismiss, and an affidavit, if applicable, that justify the application for compensation. A declaration and an expunction order aren't even the documents that the comptroller is permitted to look at. So the comptroller can't just take GS's word like, oh, I have these declarations and oh, I got an expunction. The comptroller can't even consider those documents. All the comptroller can consider is whether the habeas order here contains a clear indication of actual innocence. That's it. And he also doesn't qualify for compensation under 103.001A2C, which says you can have a habeas order based on any type of relief, and if you also get a court order dismissing the criminal case against you that is based on the state's attorney's motion to dismiss, in which the state attorney states there is no credible inculpatory evidence against the person, and further, in either the motion or in an affidavit, the state's attorney also states that the state's attorney believes that the person is actually innocent. That didn't happen here. So he can't get it under C. The habeas order doesn't get him under B. And as far as his ratification theory, there is nothing in this record that would allow this court to infer that the state's attorney ratified these declarations and determined that he was actually innocent. The state's attorney's recommendation was for expunction is very nonspecific. It doesn't say I'm recommending an expunction based on his actual innocence. It's only specific in the sense that it says I am recommending that he be granted expunction under Article 55.01B2 of the Code of Criminal Procedure. That provision is a discretionary expunction provision. And all you need for that is a person has been released and there's not a pending indictment against the person, and the state's attorney just says, I recommend that his arrest records be expunged. And I would also like to add that if the state's attorney was recommending and the criminal trial court was granting expunction based on actual innocence, there's actually a provision for that. in Article 55.01A1 of the Code of Criminal Procedure. You get an expunction by right if there is a prior court order that clearly indicates the person is actually innocent. That's not.
Let me ask you about 103.001A to C again. You were mentioning that if the state district court dismisses the charges and the prosecutor has stated the things that are required under Romanet 2, one is that no credible evidence exists that inculpates the defendant, as you mentioned. Do they have to use those words exactly, or could something like pending further investigation be read to mean I don't have enough credible evidence right now that inculpates the defendant? And I understand one response may be, well, but the thing in the motion or affidavit that they believe actual innocence is missing. And I understand your argument on that, but I'm just asking about this narrow statement that no credible evidence exists that inculpates the defendant.
I think for there to be a clear indication on the face of a motion to dismiss, the state's attorney has to use language identical or very similar to what is in the statute. If it's not there, it is hard for the comptroller to determine, it's hard for the comptroller to look at a dismissal order and determine a vague, I recommend a dismissal, or I move for dismissal on other grounds pending further investigation. I see my time is up. May I finish this answer?
Yes, you may finish.
To be clear, this dismissal order was a pre-printed form. It had check boxes on it. There is a box that you could check, and I'm forgetting the exact language, but there's a box that you could check that says the witness no longer wants to pursue these charges, something like that. But the state's attorney didn't check that. He checked other, and he just said.
Do you think that would have been close enough if you checked that box? It's not exactly what the statute says.
It's closer, but I'm not even sure if that's close enough. There could, even if the person recanted, there could be other inculpatory evidence.
Would there ever be an opportunity to challenge a state's attorney for not using the magic language? To mandamus him or her, or to get something just being withheld because they don't want to lose the election for looking like they're soft on crime or whatever?
I think there's a possibility for that, but I would also, I would be remiss if I didn't point out that there is a way for GS to get those findings. He can go back to the district attorney and say, hey, this dismissal I got wasn't good enough. If you say these things, if you agree that I'm actually innocent, say it this way, and then that will allow me to get compensation. And he can get an amended dismissal order, which is exactly what happened in the In re Alfred Brown case, and this court said that was fine. The comptroller cannot question an amended dismissal order, even though the earlier dismissal order didn't contain the C language. Thank you.
Any other questions? Thank you, Mr. Lamberger.
May it please the court. I'd like to address laches because the common law defenses of laches implies that I abandon my claims and just go somewhere and go to sleep. I would think that it is reasonable for a layman to persist in making applications for compensation, trying to find another way to appease the comptroller's requirements. And in this case, my client did that, and he did that for almost 5 years. And when he finally realized that those efforts are going to not be fruitful, then he hired an attorney and we filed a writ of mandamus. So I would submit that those subsequent applications that he filed, several of them outside of the 3-year period, but shows that he didn't give up his claim. Laches should not apply because he still was adamantly pursuing his claim, not sleeping under a log. The Court of Criminal Appeals rendered their opinion on May 17th of 2014. Therefore, he had until May 17th of 2017 to apply for compensation. If I misspoke earlier, I apologize. I think he applied, there were 2 of those applications that were within that 3-year period. He complied with the statute, and thus, if he's going to seek judicial review, I would submit that 16.051 applies, and that would give him until May 17th of 2021 to file a writ of mandamus. And that this mandamus was filed within that 4-year period. I'd like to go back to talking about actual innocence. I'm going to reiterate that the Court of Criminal Appeals in the Allen case did not find Mr. Allen actually innocent.
I have to differ with you. I've taken the opportunity since respondent was arguing to go back to Henry Allen. And even, I mean, I could read 6 or 7 excerpts where they say actual innocence, but I'll just go to the very end. Therefore, and you said they remanded instead of rendered, but what they did was they granted mandamus ordering the comptroller to pay compensation. No remand, they conditionally granted. So here's the end. Therefore, because the Court of Criminal Appeals granted habeas relief on a Schlupp claim, Allen's court order clearly indicates on its face that relief was based on actual innocence. The petition for writ of mandamus is conditionally granted, and we instruct the comptroller to comply with this opinion and compensate Allen under the terms of the Tim Cole Act. So as I read that, and again, I could pick 5 or 6, but Allen specifically and expressly concluded that the CCA had, in that gentleman's case, granted relief based on a finding of actual innocence, and therefore conditionally granted mandamus specifically ordering the comptroller to pay compensation.
I agree that this court in Allen did that, but the Court of Criminal Appeals in the Allen habeas case said, we hold that the trial counsel provided ineffective assistance to the applicant in this case. There was no finding of actual innocence in the Allen Court of Criminal Appeals opinion. That's why it was reversed and remanded for a new trial to Dallas County.
So is your argument that this court incorrectly construed the CCA's opinion in Allen?
No, sir. No, sir. I think they correctly construed it because the evidence showed subsequent to that the case was dismissed. They didn't re-prosecute it. There was sufficient evidence in the Allen case for this court to jump across the river and find that Mr. Allen was actually innocent.
But do you agree that for the CCA to have granted habeas relief in the opinion that you're discussing, the CCA necessarily had to have found a reasonable probability of actual innocence in Allen?
They didn't.
But do you agree that they necessarily had to have?
Not necessarily.
So then you think this court incorrectly construed the CCA's opinion in Allen, because we said in our Henry Allen case that the CCA necessarily had to have found actual innocence.
There was additional evidence in the record in the Allen case showing that the case was remanded for a new trial and that the prosecutor elected not to try him. If that doesn't show actual innocence, I think that this court inferred, based upon the totality of the circumstances in the Court of Criminal Appeals opinion, the fact that there was evidence of exculpatory evidence, that this court found compensation, and I think it found it correctly, I think it looked at all of the elements in that case. It looked at the fact that the court found, I want to say the Court of Criminal Appeals found in the Allen case, and I have included that opinion in my brief. Court of Criminal Appeals found that there was an effective assistance of counsel, that counsel should have investigated this exculpatory evidence and did not, and that should have presented that at trial. And that when you add that into the fact that the district attorney was remanded for a new trial, because as I said earlier, if they had found actual innocence, they would have reversed and rendered, and there would have been a remand for a new trial. So when this court saw that, and they saw that the district attorney elected not to prosecute, then this court correctly decided that Mr. Allen was actually innocent. Just as in my case, when the Court of Criminal Appeals remanded for a new trial, the district attorney elected not to prosecute, dismissed pending further investigation, and then agreed to an expunction. I think in those cases, both. I'm asking you to kind of jump across the river too, because you have to look at all of the facts that are submitted in the record. And in the Allen case, that shows that Mr. Allen was actually innocent. And I think in this case, this shows that my client is actually innocent.
Any other questions? Thank you, Mr. Radford. The
Thank you,
case
sir.
is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
Thank you, Mr. Lineberger. We'd love to.